Good morning, committee, everyone in the room. Welcome to House Judiciary on this beautiful Friday. We're very optimistic. We're going to get through 3 bills today in 2 hours, so we want to keep the testimony tight and on mark, and questions likewise, and we will see if we can get 3 bills done this morning. Here, call the roll, please.
Representative Brady?
Here.
Representative Breton?
Here.
Representative Chestek?
Here.
Representative Filer?
Here.
Representative Kelly?
Here.
Representative Lean?
Excused.
Representative Singh?
Here.
Representative Webb?
Here.
Chairman Washut?
Here.
You have a quorum.
Thank you. Director, you want to tell us a little bit of the background on Senate File 9?
Yes. Mr. Chairman, co-chairman, committee members, I'm Dan Shannon with the Department of Corrections. Thank you for allowing me to be here today. Senate File 9 is a product of last year's interim committee for Judiciary. It's a combination of really 2 statutes, 713-105, which restores voting rights for convicted felons that meet certain criteria. That was established in 2017, but was retroactive back to 2010. The second part of the act is 610-106. It's a restoration of other rights, which includes jurors to be an elector, as well as your firearms. And that took place on July 1st of 2023. The interim Judiciary Committee last year worked to address just a few issues. Some of it was vocabulary to notify DCI. DCI was being notified, but we wanted to have it in statute. ATF added explosives to their departmental name and requested that we add that. Eligible voter citizens. The rest, in order to become to reserve your right, you had to be eligible to vote, which really defined residency and citizenship. And the last one was that firearms would only be from Wyoming convictions. And I have a few stats here, if I may.
Please.
Mr. Chairman, since such time, since 7/1/23, which would be other rights, would be firearm rights, we've reestablished 1,110 citizens. On voting rights, that goes back to 2010, it was 4,486. This program has been extremely successful. Since regarding the other rights, we've had 3 individuals arrested, and that's been 20 months, so that's 3 out of a little over 1,100. And going back to 2010 on voting rights, it's been 224, or less than 4%. So I can respond that 96% out of the last 14 years have been successful. So I think it's a very successful program. The issue regarding the felony convictions, we have restored 63 individuals, because by the current statute, we had to restore their rights, and those were individuals living in Wyoming that received felony convictions from the federal level. And those folks are at jeopardy. They have their rights restored. So the statute requires that we do so. But by doing so, the federal authorities have disagreed with what our statute is.
So does this bill draft fix that?
It does, Mr. Chairman. And last thing, one of the statistics that I'd like to say, we restore on other rights, living in Wyoming with out-of-state convictions, the number's been 71, and living out of state with Wyoming convictions, we restored 164. So that gives you some idea of the folks that maybe went to another state and returned back, committed a crime, then returned back. To be restored with these rights, it has to be a first-time felony, nonviolent. There's a number of criteria that they have to meet. They can't have 2 competitive convictions together. So it is very stringent in that aspect. Mr. Chairman, if I may, I'll work through the bill real quickly on the amendments.
Please.
The first amendment is on page 3, and it clarifies that the Department of Corrections will automatically restore voting rights for
Are you on the blue and gross version, page 3?
I am, Mr. Chairman.
Okay, just want to make sure we're all on the same document. Okay.
Yes. The First Amendment on page 3 clarifies the DOC will automatically restore voting rights for qualified persons convicted of violent felony arising out of the same occurrence upon obtaining age 18. This language provides clarification that the department only has the authority to restore voting rights to individuals who lost their voting rights due to felony convictions. On amendments on page 3 and 4 also provide clarification that individuals with nonviolent felonies under the law of the state of Wyoming arising out of the same occurrence or related course events, what I mentioned earlier. On page 4, lines 13 through 15 amendments specify that a person convicted of a nonviolent felony or nonviolent felonies under the laws of another state may be eligible for restoration of voting rights. So what's different in our practice from this amendment, more especially I believe on page 8, is your code committee changed, the interim committee required that other rights, which include juror, elector, and firearms, is only for Wyoming convictions. When this bill went before your code committee, amendment was changed, that's on page 8, that said firearms shall be Wyoming convictions only, but other rights, which would be the right to vote, elector, and juror, shall be convictions. It could be convictions from out of state. So that's a change from the interim committee. And it's different from our practice currently. If you go to page 7, lines 8 through 17, amends the notification process requiring notification of restoration of rights to be sent to the Federal Bureau of Alcohol, Tobacco, and Explosives, as well as the Division of Criminal Investigations. This amendment provides to correct the entities which need to be notified, which they currently are and remain to be. And amendments on page 7 and 8 regarding section H makes it clear that a new felony conviction in any jurisdiction resulting in a removal of rights. The reason for that is 713-105, the voters. It never clarified that if you received a new felony, that would automatically be void or not processed. 610-106 did, so we combined the two. And it's the agency's understanding that on page 8, section J, that section J is the one that really works with the other rights, and that's what I spoke of earlier about the code committee. It's intended to change the current process by specifying that those who are convicted of non-violent felonies or arising out of the same occurrence within the state of Wyoming only may have his or her right to possess a firearm. So the difference, Mr. Chairman and committee, would be, it would be Wyoming convictions only to have if you meet the criteria for firearms restoration. Your other rights, which would include juror, elector, would be from any other state. It's similar to voting. And these are only after you complete your sentence, your time, then you have a 5-year period afterwards we do background checks and such on them. They did after 5 years, after they've completed their period of incarceration and supervision, they've been 5 years clean before we consider it. Mr. Chairman, I'll stand for questions.
Nicely done, Director. Any questions for the recommended filer?
Thanks, Mr. Chairman. If we restore somebody's firearm rights here in the state of Wyoming and they move to another state, I understand we send whatever to DCI and the Federal Bureau of Alcohol or Firearms and Explosives. Do their rights follow them? Those restored rights follow them to any other state, or is it just Wyoming?
Director?
Mr. Chairman, Representative Filer, it's only the location in Wyoming. And I'll give you an example. Under the current statute, we've had 3 individuals. The example would be if you're from Ohio, you can file in Wyoming with your voting rights and remain in Ohio. It doesn't do you any good unless you come here because they're separate statutes. So it only remains in Wyoming. The firearms rights would be. The out-of-staters, I could see where it'd be a benefit. I don't really have the statistics if a person was coming to hunt or things of that nature, where you would have your firearm restored. That's what it previously is, but we would end that so it's only Wyoming residents with Wyoming convictions.
Representative Filer, follow up?
Yeah, thanks, Mr. Chairman. I think what I was saying is, like, if you have a convicted felon that resides here in Wyoming, was convicted of a felony in Wyoming, but then we restore their rights, but then they move to another state for whether it's work, whatever it might be.
Right.
I think I wasn't worried about people coming here trying to get their firearms restored. I was more worried about somebody that's a resident of Wyoming, but now is no longer a resident.
Director.
Mr. Chairman, Representative Filer, regarding reciprocity, some states do have it for voting rights, but they do not for firearms.
Further questions? Representative Bratton.
Thank you, Mr. Chairman. If this were to pass, how do you notify people post facto? Or is that a question for later after I just want to make sure you're still around to ask you, if we clarify the language on these certificates, then how do we let the people know who already have their certificates? Are we going to issue more certificates, a new updated certificate? I guess that's my question.
Director.
Mr. Chairman, Representative Bratton, the law would take effect probably, I don't think it'd be upon signature, July, 1st of July. So it would only affect those going forward. We do notify the ones, the individuals that received notification for federal. It's on our website. It's on our letters. We put it in bold on a certificate. I mean, we're doing everything that we can. When they file an appeal, or I personally send a letter indicating you need to seek counsel because this has been a federal conviction. I mean, I'm doing everything I can, but I also have to stay within the confines of the law.
Further questions for the director? Seeing none. Thank you very much. You might stay around. We might have some more questions pop up before we're done.
Thank you, Mr. Chairman, Committee.
Mr. Chambers, Mr. Thompson, anybody back there interested? Anybody else in the room want to testify on this bill? Anybody on Zoom for this bill? All right. You want to close public comment on Senate File 9? Committee, what's your pleasure? Moved by Chestick, second by Singh. Any amendments? Any amendments? So committee, just let me, as a state legislature, we can't alter or change federal law. But it also was my understanding that for non-violent felonies, that if a state restores a person's rights, they no longer qualify as a prohibited person under federal law. Where we got jammed up was when people who had federal convictions under federal law got documentation from us saying your rights have been restored because they also had a Wyoming conviction and they thought they were free to go with the firearm stuff. So if that's an accurate understanding of when you are or when you are not a prohibited person under federal law, then if your rights are restored in Wyoming, you would be considered not to be a prohibited person by the Bureau of Alcohol, Tobacco, and Firearms. But I'm not an expert in that area, but that's my layman's understanding. So this is an important feature that when we restore somebody's rights, certainly it's clear that if they've only had convictions in Wyoming, that their gun rights are valid here in our own state. And I think that by itself is a huge and important step forward. So any amendments, suggestions, discussion? Call the roll. Representative Brady?
I'm sorry, I just had a question for clarity is all, and I'm sure it's very simple. I was taking notes as long while he was speaking. So the Deputy of Corrections while he's speaking. So if they have, where are my notes here? So after 5 years clean, following the incarceration and then the probation, then after the 5 years, then they would get back the gun rights, or is it the voting rights? Voting rights second? Shirley?
The voting rights, I believe, is automatic. They don't have to apply for that. For the other rights, they would have to make application.
And that's 5 years after, right? Or, okay. Thank you.
All right, further questions, comments? Representative Singh?
Thank you, Mr. Chairman. I just wanted to say that this was one of my favorite bills to have voted for in 2020, in the last legislature when we were able to talk about this. This was a really important topic, the restoration of civil rights for folks. And this is the appropriate cleanup from that conversation, and I'm grateful that we're able to work on this.
And thousands of people have taken advantage of it, so here, let's call the roll.
Representative Brady,
Aye.
Representative Breton,
Aye.
Representative Chestek,
Aye.
Representative Filer,
Aye.
Representative Kelly,
Aye.
Representative Lean,
Aye.
Representative Singh,
Aye.
Representative Webb,
Aye.
Chairman Washit.
Aye.
9 ayes do pass.
Volunteers carried on the floor. Vice Chairman, very good. Thank you for moving expeditiously through Senate File 9. Director, thank you for being here on that one. That takes us to Senate File 100. Senate File 100, which is Child Witness Courtroom Procedures. Let me text Senator Schuler really quickly. She said she was in another meeting. She's education meeting is meeting jointly. So we'll just take about a 2 or 3 minute recess while we wait for Senator Schuler to move across the hall. All right, I'll call the committee back to order. I think Representative Filer will be back in just a moment. But Senator Schuler, welcome to House Judiciary. Please walk us through Senate File 100.
Thank you, Chairman. It's good to see you again. I enjoyed the time that we got to spend together on Judiciary. I kind of miss it a little bit. But anyway, I bring you Senate File 100, Child Witnesses Courtroom Procedures. This bill actually came about as a result of some of the testimony we heard in Joint Judiciary about some of the issues we're seeing with the increase, unfortunately, with sexual crimes against our Wyoming children. And then obviously them having to be re-victimized in the courtrooms to testify against their offender. So what Senate File 100 does is it allows a child less than 16 that was amended, I'll mention that a little bit later, in case of sexual assault or incest to testify outside the presence of the defendant and the jury. So before allowing this kind of testimony, the court has to hold a hearing, and they have to decide if testifying in the courtroom would cause the child to suffer more than de minimis emotional distress, and that remote testimony by the child is necessary to protect the welfare of the child. So it's in the court's hands, basically. The court may also exclude the defendant from being physically present in the same room if they're present would substantially, again, that's the key word, if it's likely to cause substantial emotional distress to the child, or if it would impair the ability of the child to communicate. So if the defendant is excluded, the child may testify by the way of a closed-circuit TV or other appropriate technology, and it shall be televised live in the courtroom simultaneously. The defendant may waive the right to have their image televised in the room in which the child is testifying. The defendant may, however, though, communicate by audio system with attorneys outside the courtroom. So again, if the district attorney finds that there would be substantial emotional distress to the child, again, the court may exclude the jury also from the room in which the child is testifying. So again, the child's testimony would be televised, though. And again, if the defendant is charged with incest, sexual assault, human trafficking, or a violent felony, and a child less than 16, again, this was amended to less than 18. Right now on the books, it's 12. You start looking around at some of the other states, most of them have gone to 16. So that was kind of the reason that I chose 16. But our committee over on the other side amended it to less than 18, which I thought made sense. Here are some of the following accommodations that the children can get. They can be free of nuisance or harassing tactics in the proceeding. They can have a person who would contribute to the well-being of the child that can be close by and visible. They can have sufficient breaks in the proceeding to allow for the comfort of the child. They can have a certified therapeutic dog present in the room with the child. So those are accommodations, they don't have to use them. And again, if the prosecutor decides to utilize the videotape deposition, then the child is unable, if they will not, or is unable to provide live testimony, and the videotape has been taken and it's admissible, then the child may not testify in court under the consent of the defendant. So anyway, I did have some questions about the confrontational clause. And the confrontational clause of the Sixth Amendment, it generally ensures a defendant a face-to-face meeting with witnesses appearing, but there are exceptions. And one of the exceptions is if the government interest in effective law enforcement outweighs the benefit of confronting the witness. Also, there have been a couple of court cases that have gone all the way to the U.S. Supreme Court. One of the ones that kind of ties in with this is U.S. versus Gaddis. And basically, it imposed reasonable limits on cross-examination based on harassment, prejudice, or the witness's safety. This was an 8-year-old girl that had been sexually traumatized. So there are exceptions. The court has to decide if it's reasonable to go ahead and exclude this child and let them do the remote. So in essence, remote testimony does not infringe on the accuser's confrontational rights if it's a necessary matter of public policy. Again, South Dakota just passed this bill. I kind of used theirs, had some good help here in the room. I used their bill that passed, I think, 2023 as kind of a model. It hasn't been litigated. Some other states have also gone this route. So I think it's in pretty good shape, the bill is. Bottom line is we're just trying to protect our young victims of sexual assault, incest, violent felonies, and human trafficking by giving the courts the option to allow these victims not to be re-traumatized. And I do trust that the courts will use this option rarely, but whenever it's necessary. With that, I would stand for questions.
Senator, obviously we have a confrontation clause in our own state constitution. Has the Wyoming Supreme Court weighed in on a similar topic or given us any inkling? I know this is new law, so we haven't had litigation on this specifically, but the existing case law on the confrontation clause in the Wyoming Constitution, anything?
Thank you, Mr. Chairman, for the question. No, I looked back and I didn't see anything that really pertained to this at all. I did look, like I said, thank goodness I'm not a lawyer, because looking back through case law, this is kind of boring myself. But anyway, I didn't see anything from our state that pertained to this at all, so.
Representative Kelly.
Thank you, Mr. Chairman. I'm in full support of this bill, but I do have a question, just curiosity, because I have experience working with minors who have been traumatized, brutalized by criminally abusive adults, but it wasn't always sexual in nature. So why is this limited to incest and sexual assault and not like severe physical abuse in other manners too?
Senator.
Thank you, Chairman and Representative Kelly. Actually, it does eventually, if you read back through, let's see, let me find the spot on the bill. It does actually get into, I can't remember which page it's on. Page 4, okay. And it does bring in the violent felony. And we did have some discussion, and there may be some more about strangulation. That was actually a question that was asked, so that's really a good question. But I think this takes care of it. Even though we're kind of focusing on incest and sexual abuse, it does bring into this bill violent felony
Further
and
questions?
human trafficking as well.
Further questions for the senator? Why don't you stay close if you could?
You bet.
Just in case there's other testimony. Others in the room wishing to testify on Senate File 100, please come forward. Make sure your green microphone light is on. Introduce yourself to the committee and tell us what we need to know about Senate File 100. I'll start with you, Ms. Nelson.
There we go. Thank you, Chairman and Representatives. My name is Stacy Nelson, and I am the Executive Director of the Children's Advocacy Project in Casper, Wyoming. We are a child advocacy center that provides forensic interviews primarily and therapy services and victim advocacy services for kids in our community. And we actually serve about 14 counties. So when I say a child advocacy center, we're accredited through the National Children's Alliance. Wyoming only has 3 centers in our state. And we have, in Casper alone, I mean, this talks a lot about the sexual assault and incest. Last calendar year, we did 262 interviews, and of those, 190 of them were for sexual abuse cases. And we are clearly in favor of the bill because we see a lot of these cases go to court, and knowing the trauma, a big piece of the Child Advocacy Center, I should back up, is minimizing, doing everything we can to minimize trauma. We all know, and we're becoming more and more educated about the impact trauma has on children well into their adulthood. You know, everyone discusses ACEs, that's been spoken about a lot more in the recent years, but it really does have a serious impact on the kids and their well-being. And so we, as a Child Advocacy Center, we really want to do everything we can to minimize that. And part of that process is with a forensic interview, the child only speaks to the forensic interviewer, and the law enforcement prosecutors, they're in a different room and can watch that so that if questions come up during the break, they can address that with the interviewer who then talks to the child. And that's a big piece of it, is making sure the kids don't have to repeat themselves over and over. We know when it comes to court, they will have to testify again. And for these kids, it is terrifying sometimes for them to have to see their, the defendant in the room. And so we've really been advocating for anything that can help minimize that for them. We understand the Sixth Amendment right, but I think it's important to find that balance so the victims also have that opportunity. I know there's the question, we really did hope for that addition of the physical abuse and the felonies because our second most common abuse type is the physical abuse and strangulation, those kind of things. So we see a lot of that, and I can tell you just when I'm not in the executive director role, I do the victim advocacy role because we all share duties at CAP. And we've had cases. I know I had one that I was working with, and the child had been sexually abused by her adopted father for years, and she finally spoke up. And when she came out, she was so relieved when she came out of the interview room, and she said, "I'm so glad I finally said something because my sister's at the age where it started with me, and I just wanted it to stop and not start with her." And in her case, the father did confess to things, so the trial didn't have to happen, but just the piece of helping her with her victim impact statement was so difficult for her. She ultimately could not, she still couldn't, through after therapy and everything, she couldn't find the courage, I guess, to be able to speak up for the victim impact statement. So just knowing how difficult that part was for her, I could name off so many cases where kids, have had to testify in the trial, and how difficult that is for them. And that's sometimes why there are plea agreements. So anything we can do as a community and as a state to help those children, we are certainly in favor of, so.
Committee, any questions for Ms. Nelson? Thank you for what you do, and I think, most people, I think we go through life fat, dumb, and happy, right? And we just stay ignorant of so many of these traumas in our world. And the fact that you did 262 kiddo interviews last year, that's heartbreaking. Chief?
Mr. Chairman, my name is Mike Thompson. I am the Chief of Police for Evansville. And like many of us in Wyoming, wear other hats. I'm the chairman of the DFS Oversight Council, along with being a board member to the Child Advocacy Project here in Natrona County. I'll keep it mostly brief here. Some interesting statistics. 1 in 5 girls and 1 in 20 boys is a victim of child sexual abuse in America. Under self-report studies shows about 20% of adult females and between 5 and 10% of adult males recall a childhood sexual assault or sexual abuse incident in their lifetime. During a 1-year period in the U.S., about 16% of youth ages 14 through 17 have been sexually victimized. Over the course of their lifetime, 28% of U.S. Youth have been victimized. And in these cases, there tends to be evidential problems sometimes with child sexual abuse victims. A successful abuse prosecution generally requires the child victim testify against the offender. Often in cases of this nature, there is very little, if any, evidence to corroborate the child's account of the offense because of the secretive nature of the crime itself. Most sex offenses, therefore, must be proven by the testimony of the victim collaborated in the prosecutor, or if the prosecutor is lucky, by medical and/or laboratory evidence. Thus, the victim's testimony or testimony regarding the victim's statements about the incident is absolutely critical in these cases. Cases involving young victims often are complicated further by delay of reporting of the offense. It's not unusual for the child to keep the fact of the incident secret for weeks, months, or even years before it becomes reported. Typically, the offender has threatened the child with physical harm, and the threats are taken seriously. Moreover, children often feel ashamed of their involvement and will not immediately tell their parents and or other adults what has happened to them. This is especially true if the offender is a member of the childhood's household, to include sometimes even the other people in the home. So if it's the husband that offends, the mother tends to protect the husband at times, so that creates some of those problems. We had a case in Evansville recently. The boyfriend of the mother severely abused 2 children. It was the worst child abuse case Children's in Denver has seen in 7 to 8 years. Both kids were life flighted. Many threats were made, and although it was not sexual in nature, that's part of the violent felony part of what we've been talking about. And in the court process, the re-victimization is a concern. And when Stacy did a presentation at one of our DFS Oversight Council meetings is when I learned of this issue and why we're talking about it today. The process can be intimidating for children, and the experience can be traumatizing or re-traumatizing to them. In the spirit of fairness, state laws can vary through and can leave the courts without consistent approach. And it's one thing about the state of Wyoming, each judge has essentially their own way to handle things within their courts here. And so passing SF 100 essentially has a uniformity across the state is one of the things we're looking to do. I did some research after this came up, and there's a lot of procedural reform starting to happen across America right now. Many states have introduced procedural reforms to reduce the trauma on the trial end of this for victims. Montana and Colorado, which both sit in the 10th Circuit, which we were part of the 10th Circuit Court, have similar laws. From what I can find, Montana's goes back to 2007 and has not had any of those challenges on their end, and I've not seen anything out of Colorado. Both North Dakota and South Dakota have similar laws. They're in the 8th Circuit, and from what I can tell, they have not been challenged either on their end. The language that we use from South Dakota was modeled after Colorado, Montana, and North Dakota, is my understanding. And with that, Mr. Chairman, because I know we're on time, I will stand for questions.
Questions for the chief? Thank you for what you do with the DFS oversight. A very important role. People sometimes don't realize how many other hats police chiefs end up wearing, and appreciate your service in that regard. And does your daughter have some testimony for us?
Yes, Mr. Chairman. My name is Brenna Thompson. I currently reside in Natrona County. I'm here to testify to support Senate File 100 and offer my own experience in a court. During a civil trial, I was the subject of a custody battle in 2017. However, I do feel this is relevant for people who do become victims of physical, sexual, and domestic abuse and human trafficking. Before I ever entered the courtroom, I was unfortunately intimidated by a lawyer before I even entered the courtroom. With that experience, I feared seeing her in the courtroom as long as everybody else that was going to be there. I had anxiety. I was fearful that my testimony was not going to be heard as truthful by the judge. This was coupled by having repercussions with family members in and out of the courtroom. This experience I was involved in led to me going to counseling for 2.5 years. It provided me a safe space to get what I truly wanted to say and wish I could have said during my court experience. I got to start my journey to heal in counseling. Once before I was even allowed in the courtroom, my guardian ad litem took me into the courtroom with nobody there, told me what was going to happen, presented the room to me, told me where everyone was going to sit. He tried to take away that anticipation, trying to get me to be prepared. Unfortunately, with that, I was more overwhelmed, scared, and I felt pressured, and I felt that I was going to be vulnerable and felt exposed, that I was going to have to sit in front of all of these people. Prior to being called into judge's chamber, let me back up. I was not called into the courtroom. I was called into judge's chambers. It was a last-minute thing. Upon going into judge's chambers, I had learned I was not going to be allowed my guardian ad litem or other counsel in the room. With that said, last time we came here, a senator had motioned to put shall instead of may into the language. I support the shall just because I feel like if my guardian ad litem had been in the room with me, with Chambers, I would have been able to give my testimony as I intended and to be more heard. So I'm hoping that you guys will consider putting shall versus may in the language, so that way our child victims can have emotional support on the stand and have their voices heard as they intend, instead of having to feel like they cannot say exactly what they want to, based on intimidation in and out of the courtroom. During my middle school and high school, I interacted with classmates. Several I became friends with. One of them in particular, I learned they had been sexually assaulted by their brother. She had a lot of fears and anxieties like I did, felt like she was going to also have to feel vulnerable and exposed in the courtroom. She was scared for repercussions outside of the courtroom too with her family. So she felt a lot of those same anxieties, and unfortunately did not have a whole lot of support behind her. I've come to learn, because of all these experiences I've had and that I've watched fellow classmates go through, and just general kids. Obviously, I'm a cop's daughter, so I hear stories when he comes home, cases he's been called to, and I often think about how those children felt and how exposed they might feel, especially because their cases are severe. So Yeah, so even though my court interaction was civil, I hope that those insights of fears and anxieties can resonate with you guys and help our kiddos out, because, yeah. So with that, I stand for questions.
Did a very nice job.
Thank you.
Any questions? Representative Bratton?
Thank you, Mr. Chairman. Did the court say why they wouldn't allow you to testify remotely?
Yes,
Ms.
Mr.
Thompson.
Chairman, Representative Bratton, I don't know the answer to that. I was not told if that was the case, so, yeah.
So, Ms. Nelson or Chief, maybe one of you know, do any of the other states have shall as opposed to may? Have they mandated the judicial branch
I
do
am
these things?
honestly not sure, Chairman.
Chief, you know?
Mr. Chairman, I do not know. I know the language out of South Dakota was a may, and there was a healthy debate in the Senate committee about shall versus may, and the court wasn't there to weigh in, Mr. Chairman.
We sometimes tread lightly when we're talking about another branch of government as to how much we want to try to mandate from the legislative side, but it's a worthwhile discussion. But thank you for bringing that topic up.
Mr. Chairman, if I may.
Final comments? Yeah.
As a parent, I got to obviously go through this and deal with this with my own child, and I don't want to say all the judges in the state are the same, and to the heart of it, I would support the shall because of the experience I went through, and it may just be that particular judge because of the trauma that she went through, and maybe that's why we have the interest in the shall versus the may. Also, a couple of things, and I forgot to mention this earlier. Strangulation is one of the things that I felt that we should consider adding. It may fall under the violent felony side of it because it is a violent felony, and also aggravated assault, even though it's not a felony per se, 62502AI, aggravated assault. This child abuse case that I referenced earlier, these two kids, essentially, if you've ever watched Looney Tunes and watched Foghorn Leghorn beat the cartoon characters up, is essentially what happened to these two kids. So it wasn't necessarily a sexual assault, but as we know, sometimes in the court, although we may, in law enforcement, charge this as a felony, sometimes it gets knocked back to a misdemeanor. And so in the world of ag assault and what that does to the mental status of a child, I feel it may be appropriate to add that as well, Mr. Chairman.
Any other questions from the committee? Thank you. Is there anything else you'd like to say? All right.
All right. Thank the three of you for testifying. Any final comments, Ms. Nelson? All right.
No, Chairman, thank you.
Thank you. Ms. Chambers? Come on up if you want to join her at the dais.
Good morning.
Good morning,
Kara
Ms.
Chambers, Wyoming Attorney General's Office, Division of Victim Services. I just wanted to read out all of the crimes that are encompassed under the definition of violent felony for everyone's edification. Murder, manslaughter, kidnapping, sexual assault in the first or second degree, robbery, aggravated assault, strangulation of a household member, aircraft hijacking, arson in the first or second degree, aggravated burglary, third or subsequent DV, sexual abuse of a minor in the first or second degree, and felony interference with a peace officer.
Pretty encompassing.
Yeah.
Thank you. Further testimony? Anything?
Chairman, just here to answer any other questions as they come up. I did do an analysis of all the other states. I did not hone in on the shall or may, which I can do. But I do think you usually see may when it comes as for the reasons you've already stated. But I did see at least 32 other states that have laws pertaining to this.
Could I ask you to maybe do that research on the shall or may before second or third reading, and maybe we would bring an amendment if it seems like that's a viable option?
Chairman, I would offer that's a policy decision for you, but I'm happy to do that. The only analysis I had previously done was the ages.
Representative Chesty.
Thank you, Mr. Chairman. Ms. Chambers, in your research on the other 32 states that have similar bills, did you encounter any cases that were challenged, where these cases were, the statutes were challenged under the confrontation clause, and what were the results?
Ms. Chambers.
Chairman, Representative Chestick, the one that I recall, again, that wasn't the sole focus of my inquiry, was Colorado, that under similar reasons, Colorado's law was deemed unconstitutional for, it was a pretty broad statute, however, but it was deemed under the confrontation clause and other issues that they had.
Anything else, Ms. Chambers? Questions from Ms. Chambers? Oh,
questions.
Representative Kelly.
Thank you, Mr. Chairman. Going back to the Shell versus May, I really appreciate that someone else is going to look into this who knows more about it than I do. I just wanted to add one perspective I'll ask you to consider, and that is my experience knowing that teens, especially adolescents, as their minds expand to accept the abstract and they begin to really absorb what had happened to them with more of an adult mind, that they may wish to deal with their trauma differently, and some may wish to confront their fears head on as 16 and 17-year-olds. And that's why I'd be reluctant to make it shell, because you may be taking away what could be very therapeutic to some teens.
Ms. Chambers.
Chairman Washut, I would concur. I don't know that there was fully a question in there, but I would agree. And I think the shall and the may is more directing the court's ability to offer this, but I would agree. And again, leave that to a policy decision for the body.
All right. Yeah.
Chairman, representatives, my name is Jewel Parrish. I am the executive director of the Child Advocacy Centers of Wyoming, so I represent the 3 CACs that we do have in the state, as well as expanding those resources to other counties and other areas across the state. I bring in resources, training, anything that our CACs need. Prior to that, I was a CAC director and a victim services program director, and I have sat with many victims, children and adults, and testifying is a huge issue. I've had adults break down and cry because they have to get up in front of people and tell their story. I will bring a child that I worked with. She came to our center at 8 years old, and it was in a county and a judge I had never worked with before. And I was confident in what I was telling this child. I told her I would be there with her as her advocate throughout the whole process, because that's what I had before. Through this, she suffered severe sexual assault from her father. Her mother decided not to believe her, and she ended up going into foster care because she was being abused by her mother on top of that. So she was put into foster care, eventually into a group home. So I sat with her through many attorney meetings, many counseling sessions, group therapy, all of those, telling her that it was going to be okay. We got to trial, and I said, I will be in the courtroom. If you need a reassurance, here's where I will be sitting, because that's what I had in my arsenal. The judge had decided last minute to expel everybody from the courtroom. Only the jury, the defendant, and the 2 attorneys were allowed in the courtroom. So that child lost everything and she cried to me before when we found this out. You said you'd be with me the whole time. And I said, I'm sorry that I can't. She broke down on the stand and was not able to testify on her abuse. And her abuser got away because the jury didn't convict, because there was no direct testimony from the child. So this is why this bill is very important to me. As a CAC representative, we very much so, we support the child, we make sure they're in counseling, any family members can get therapy, things like that. And when we get to the court systems, we want that extra protection to the child to know that we are there with them. the traumatic, they go through the trauma of the abuse, they go through the trauma of having to tell people, and then they go through the trauma of having to retell people in a courtroom. So this bill, for me, shows that we're giving that child an extra bit of protection.
Question from Ms. Harris, right?
Parrish.
Harris. Any questions? Thank you for being here. I think that's enlightening to hear those, anecdotal stories of what really occurs in our Wyoming courtrooms. Thank you. Anyone else in the room? No? We're getting a head shake in the back? All right. Mr. Thompson? No? Anyone on Zoom for this bill? Senator Schuler, give us any parting comments before we close public testimony?
Thank you, Mr. Chairman. Just a chance to follow up on the great testimony. Some of the testimony that we heard over on the Senate side, we also had heard from another person that was talked about being traumatized by this. And I also did a little research on my own. I like to go out and talk to some of our district attorneys and those kinds of things. And as they mentioned, it's happening more and more. It's unfortunate what's going on in our society. And, ultimately, we want to protect our kids. We want to make sure they have a safe environment, whether they're victims of sexual abuse or felonies or whatever. We want them to be able to tell their story. And this bill is going to give us the tools to do that. And so I just hope you'll push it forward.
Representative Lee.
Thank you, Mr. Chairman. Thank you for coming today, Senator. My question is on page 2, from lines 9 to 14. It talks about the court shall hold a hearing before this. In the research that was done putting this bill together, did anyone consult the courts about making sure those hearings weren't going to be burdensome?
I did talk to, again, a couple of folks just in our county. And, the bottom line is it's still in the court's hands. So they can say, no, we don't think this is going to cause substantial damage and you're going to have to testify. Over on my side of the state, we probably haven't seen as many cases as what we're seeing in, Casper, Cheyenne, whatever. But thus far, the folks I talked to didn't seem to feel like it was going to be a big burden. And again, those accommodations are optional. So again, they can choose to allow those or not. So.
Thank you very much. With that, I'm going to close public comment. Committee, what's your preference? Moved by Kelly, second by Singh. Amendments. Proposed amendments. Representative Chestic.
Thank you, Mr. Chairman. I have an amendment that I think solves the problem that Representative Kelly mentioned earlier, which I agree with. I'm still processing. I'm one who does like to defer to judges, but I understand that sometimes judges make mistakes. So the concept of my amendment is to put a requirement on the judge that the victim can opt out of. So my amendment would be on page 2, line 5, change the word may to shall, then add on line 6, after remotely, if the victim so chooses. So the default is that the victim, the court shall allow the child to testify remotely if they want. If they choose not to, if they want to come in and confront, they can do that. That's their choice. It's the victim's choice. And to make this work, I think that also requires that we delete Romanet I, lines 9 to 14. So that would be my amendment, and I propose that for see if we have a second.
I think you have a second from Representative Kelly. I saw a thumb up on that way. Let's have some discussion about whether or not Romanet I has to go away. My worry is that it's the hearing that helps preserve the constitutionality of this.
Yeah, that's my concern too, but go ahead.
So I'll let you respond to that thought.
I follow that. And I'm not sure. I would like to propose the amendment. I'd like to have it passed here, and then do some more research, because we do know of a case now in Colorado that was held to be unconstitutional because it was too broad, and I haven't read that case, and I'd like to do some more research on it. So I would like to move this bill forward with this requirement. It does make it more protective, I think, of the victim. If that pushes it past the line of constitutionality, we can always reverse it on second or third reading. But I think I would like to provide as much protection for the victim as possible, and so that's my proposal.
Okay, so the amendment is to change may to shall on line 5, and then add the words if the victim so chooses after remotely on line 6, and then strike lines 9 through 14. Pierre, you have that? Everybody clear on this? Just further discussion on this amendment. Representative Lean.
Thank you, Mr. Chairman. I feel like we're adding conflicting language by changing the may to shall and then saying if the victim so chooses.
Representative Chestick.
I don't think it's inconsistent at all. I think it actually, there's two parties here that we need to think of what their choices are. What does the judge want to do? What does the victim want to do? We're telling the judge, you must allow this, but the child can say, I don't need that. I would prefer to be in the courtroom as part of my recovery, to confront my accuser and look him in the eye and say, this is what you did to me. The change in the may to shall constrains the judge, and the other language gives the victim power. So they're two different things, and I think they are consistent.
Representative Kelly.
Thank you, Mr. Chairman. I support the amendment, and like Representative Chestick was saying, I don't think this in any way endangers the bill, and we could adopt later if it turns out there's a constitutional issue as we research this further. The first part, adding the shall, in plain language, it says, if the kid wants to, the judge has to let the kid do this remotely. So it's not really conflicting language. I think that's very important to allow that option for young adults, and at the same time, put a little more teeth in the bill.
Representative Webb.
I appreciate the comments and appreciate the concern. I would prefer to not put this amendment in right now, to think about it a day or two, put it in committee of the whole. That way we're not having to go back and forth, and we're not, what's the word I'm looking for, changing things midstream here that we have to go back and change later.
I follow that line of thinking, that vacillating in front of the body may not be the most, that if we did it as a standing committee amendment or a committee of the whole amendment, the good representatives' research could be done by then, and then we could decide whether there's some value in that argument. Further discussion? Seeing none? So we're voting on the amendment, standing committee amendment to change may to shall, include the words if the victim so chooses on line 6, and strike 9 to 14. Everybody clear on what we're voting on? All in favor say aye.
Aye.
All opposed, no. No. I think that failed. Further amendments? Okay. Call the roll, Pierre.
Representative Brady,
Aye.
Representative Breton,
Aye.
Representative Chestick,
Aye.
Representative Filer,
Aye?
Representative Kelly,
Aye.
Representative Lean,
Aye.
Representative Singh,
Aye.
Representative Webb,
Aye.
Chairman Washut.
Aye.
9 ayes do pass.
Representative Kelly, could I ask you to carry this bill on the floor? Let's look and see if we, no one on the committee is a co-sponsor on the bill, so I'm, all right, Representative Kelly. Thank you, appreciate it. Now we go to your next bill, Senator. I tried to do that, get you both bills on the same day.
Thank you, Mr. Chairman. Also,
Senate File 22.
you also got me out of a little bit of my education committee, and it was good for my vice chairman to have a chance to take over, so. I
We
do
have
appreciate-
better topics in judiciary.
They are more interesting, I will say that. Again, this bill, thank you again, Chairman and Committee, Senate File 22, grounds for termination of parental rights guardianship. This actually came as a result of some testimony we heard in Judiciary last year, and we thought about, it potentially being a committee bill, but there were so many bills, as the good chairman will let you know, and you've probably already figured that out with the number of bills you're having to look at this year. So I said, well, I'm going to take it and run with it. Because we had this testimony from a grandma that was just so passionate that it kind of piqued my interest. So the bottom line is, it's a concern again that we're seeing around the state, the number of grandparents and extended family members that are raising their grandkids, their nieces, their nephews. And so this bill provides that a guardianship with the relative and a finding of unfitness may be a ground for the termination of parental rights. And again, it's may. We heard from grandparents who've been raising their grandchildren for years as they waited for a parent to be out of jail or off the drugs or alcohol or whatever, and maybe they've gone through treatment 3 or 4 times and they're just kids get bounced around like pinballs. So I wanted to just give you some data after doing a little bit of research on this. Right now, as of 2024, there were 7,428 grandparents in Wyoming that are responsible, they're raising their grandkids. 7,428. 46% of those, they've been with their grandparents for more than 5 years. If you add in the aunts and uncles that are also raising their nieces and nephews, the total is more than 11,000 kids in the state of Wyoming that are being raised by relatives. In Fremont County, it's about 1 in 54. Goshen County, it's about 1 in 77. And 72% of those caregivers are grandparents. And I noticed that just even the last few years that I taught school, we'd have grandparents coming in for parent-teacher conference, and it just seemed to be more and more and more. And so we know that children that are raised by relatives, they thrive better than when those kids are left in foster care. They experience less anxiety, less depression. They don't have as many issues with school. They don't have as many behavioral challenges as they do when they're in foster care. I'm sure we have great foster care, and I know that they do the best they can, but children that are removed from a stable, loving home, they can experience some severe mental health challenges, and they're more likely to have difficulties with mental health and substance abuse later into their childhood. Right now, in the Green Books, there are 9 grounds in statute which pertain to grounds for termination of parent-child relationship. And the key is the courts have to have clear and convincing evidence. They may only be terminated their relationship if any one or more of those following facts is established by clear and convincing evidence. And that's based on the Wyoming Rules of Civil Procedure, and that applies to proceedings for termination of parental rights. Just to give you, before I actually give you the potential for this 10th one, some of the other grounds for termination. The child has been left in the care of another person without provision for the child's support, without communication from the absent parent for at least 1 year. The child has been abandoned with no means of identification for 3 months. Child has been abused or neglected by the parent, and efforts have been unsuccessful in rehabilitating the family. The child has been in foster care under the responsibility of the state for 15 of the last 22 months. And I want you to take note of that one, because we did have that question in the Senate side. So if the grandparent just decided to turn the child back to foster care because they didn't feel like, they could do it, in foster care within 15 of the last 22 months, the parent, if they're considered unfit, that's a termination that I think pertains to the 10th one that we're going to talk about here in just a minute. Anyway, there's 9 of those. I won't read them all, but evidence, they have to have clear and convincing evidence that the child is or that the parent is unfit. And so the 10th one that we're proposing here is, it basically says the child has been appointed a guardian who is a relative of the child, and the child has been under the guardian's care for more than 24 months. Now, on the Senate side, they amended that and said at least 24 consecutive months, and I thought that was a good catch. So, that way, if the child gets bounced around and they're with mom for a few months and mom goes back to jail or gets back into treatment or whatever, It has to be 24 consecutive months, and I thought that was a good catch. Notwithstanding any other provision of this section, evidence that reasonable efforts have been made to preserve and reunify the family is not required in any case in which the court determines there's clear and convincing evidence, and I think that's an important thing. No one wants to see a parent lose their rights. However, when I'm a child advocate, I taught school for many, many years, so I'm always going to advocate for the kids. And I've seen the results of some of these kids that have been bounced around, and it's not good. And so basically, this bill provides an opportunity for permanent stability without permanently erasing any possibility of contact with the biological parents should they become stable. So if mom gets out of jail or dad gets clean and is not on drugs, they can still see their child, they can still have, contact with their child, but they're going to stay maybe with grandma because grandma's the stable, person in the family. So anyway, this bill, I think the thing that's important about it, it enables Wyoming families to take care of their own at no cost to the state. And it helps make sure that these grandkids have a good chance at a happy, stable life. The times that we're in right now are different. They're different than when we were growing up. But we still got to protect the rights of our children to have a safe and healthy environment so they can thrive and not just survive. Again, this is just one more tool in the toolbox to provide another safety net for our kids. We're seeing too many kids that are maybe getting bounced around, or they end up in foster care and they have the adverse childhood experiences, and those experiences follow them around throughout their life. So let's get them into a safe and healthy environment where they can be cared for by a relative who's there to provide the very best care. And with that, I'm happy to answer questions.
So Senator, I'm trying to think of scenarios where maybe this doesn't fit as well. It's easy to think of scenarios where it does fit, but you have a parent that perhaps goes to jail for an unrelated felony, gets a 3-year sentence. That's 24 consecutive months plus that the kiddo is with grandparents. I guess the safety check is that the parent still has to be deemed unfit, and simply being incarcerated doesn't meet that threshold. Is that accurate?
Yes, Mr. Chairman, that's exactly right. So that grandparent, if they chose not to move forward with the termination, they would just be under the grandparent's care, no harm, no foul. But at least the kids are, still in that safe environment. So, and what we heard from one of the interesting people I thought that testified over on the Senate side was a young man that was, I think he's a junior at Casper. He'd been with his grandma, because he didn't have a grandpa, but grandma since he was 7. And he talked about all the previous things that happened. So it was almost 7 years of abuse from boyfriends, from whoever he got left with, and it was horrifying. And he said, had it not been for my grandma, I would be dead. I wouldn't be here. He's doing well. He's in an ROTC program. It was really heartwarming to hear that. But again, the grandma finally, she said, I want to be able to adopt him and be his guardian, and I can't do that right now. And so with this bill, even though he's 16, she wants to be able to be, his parent, and not have to worry about, mom coming back in or whatever. So yeah, it's, and again, the question was asked, do the parents still have the option to be in the child's life? Yes, they do. Yeah, they absolutely do. Even though they are not going to be the primary parent, they can come back and be in a part of that stable home if they so choose to with this bill.
Questions, Representative Kelly?
Thank you, Mr. Chairman. I'm always somebody who likes to just restate things in plain language. So what we just addressed there is that this doesn't prevent a biological parent from being involved in their child's life, just prevents them from coming in and saying, I want to be mom again, and causing a court struggle.
Mr. Chairman?
Senator?
Yeah, Representative Kelly, you're correct. We still, that would be the very best bet, if the parent would come back into their lives and be stable and be able to take care of them, and they still could be as big a part of their life as they want. It's just that once they've been terminated because of unfitness and some of those things that we talked about, leave it up to the grandparent or the aunt and uncle to be able to at least keep the child headed in the right direction and have some stability and know that they're not going to be, jerked around here and sent here and over to the boyfriend's house or whatever. And I think that's the bottom line.
Representative Bratton?
Thank you, Mr. Chairman. So I watched the testimony, during the interim, and I know this is a very complicated issue. I think I understand the intent behind the bill, but I'm curious, so within statute, it already says any guardian has the right to file that petition under 14-310A2, II. And so there's that one. And then there's also, a grandparent has the right to file a petition under 14-310B. So there already is the opportunity for them to file that petition. And I know that was brought up during the interim, which is, I think, why they didn't one of the reasons it wasn't taken up as a bill. Tell me why we need this, because this, adding this section is specific to a guardian who is a relative. I feel like that's even more restrictive than what's already in current statute. I'm concerned about that.
Senator?
Mr. Chairman and Representative Bratton, actually, the biggest key here is the 24 consecutive months, at least 24 consecutive months. A grandparent could apply right now, but, if the parent has not been terminated, their parents' rights have not been terminated, they wouldn't have access to that guardianship. So the parents' rights have to be terminated before the guardian can actually apply for this. I don't know if that answers your question.
I think
It comes down to a termination of the parent's right. They have to be proven unfit. And then the child has to have been with the grandparent or the aunt and the uncle for at least 24 consecutive months. I don't know if that clarifies it or if that muddies the water for you.
I think the question was, does the existing statute already give this authority, and is this duplicative? Or does this do something more for us that existing statute does not?
Mr. Chairman, I believe that's exactly right. What you're saying is it just gives us more teeth. It tells us the grandparents that they've had them for, let's say, 3 to 4 to 5 years, as we're finding, and they can go in and it's been consecutive. They can actually apply and say, the parent's unfit, and the courts can say, yes, they are. They can be with you. You can be their permanent guardian.
So the grandparent today would have to show that one of those other 9 categories applied in order to have the parental rights separated. They could not do that without the addition of Romanet X. Is that accurate?
Mr. Chairman, again, if I'm understanding the question, 10 just gives that grandparent or aunt and uncle that has been appointed the guardian the opportunity to file for termination. Right now, I'm not sure that they're able, somebody in the room that's a legal mind might be able to, it's not listed as one of the 9 right now. The grandparents or guardian is not listed as one of the 9 grounds for termination that they can apply for that. This just allows the guardian, who could be the grandparent, aunt or uncle, to apply for termination of parent rights.
Representative Filer?
Thanks, Mr. Chairman. And when we read through the other 9 and we're adding this 10, I think it's pretty clear on this. It's just another option for a family member or guardian. But, I think because that's what we got to look at is the child has been under the guardian's care for at least 24 consecutive months and showing that a parent is unfit to have custody and control. And I think that's the teeth in it. 24 months, the parent the parent was deemed unfit. So that would have to go through a court process. So I think this is a great addition to this with so many folks, especially when we add relative and we're not just pinpointing a grandparent or something like that. It could be an aunt, uncle, and so on. Because there is a lot of folks, even people that I know, a friend of mine, he's been taking care of his nieces, him and his wife, for 11 years. And they still have to fight day in and day out with the child's biological mother, who is in and out of jail, still on drugs, and there's plenty of rights that she still has, and they've got thousands of dollars, I mean, thousands in attorney fees and everything to try to get this custody and control. That way that they, one, the child's not being bounced around and having maybe some bad influences in her life, but, you know, because they provide a very well, stable environment for this young lady, but this would.
Is there a question coming in here someplace?
No, I guess not. I think I was just trying to answer the fact that why we need 10 over the other 9.
Do you agree, Senator?
Yes, I would agree, Mr. Chairman, and Representative Filer, thank you for that. Yeah, right now, the other 9 grounds do not talk about relatives. They talk about the parents, so this gives relatives the opportunity to apply.
Thank you, Mr. Chairman. In response to Representative Bratton's, and thank you for sharing with the whole list of the other 9. The question dealt with whether or not, number 1, Romanet I, would cover the situation. I don't think it does. See if you, and the question is, will you agree with me? The reason I don't think it does is Romanet I allows for the termination of parental rights if the child has been left in the care of another person without provision for the child's support. Well, okay, and without communication from the absent parent. So the communication part, I think, is what makes ours different. Number 2, the one that's being added is different. There's so a parent who gives the child to the grandparent under 1, but checks in once in a while and asks how they're doing, that stops the clock and restarts it so just by a phone call, you can stop the clock, and that, I think 10 solves that problem. You agree?
Yeah, Chairman Washut and Representative Chestick, yes, I do. Hit the nail on the head.
Okay, Representative Lean.
Thank you, Mr. Chairman. Along the Roman numeral I, this was my concern, is that it says the courts may disregard occasional contributions or incidental contacts of communication. And so my question was, does that not clarify that it doesn't have to be a consistent communication, and that the courts may say, well, you came in for a birthday party and a 3-day weekend, but for 14 months, the grandmother has had him. Does that not clarify that they could then apply for guardianship?
Senator?
Mr. Chairman, Representative Lean, that's a good question, but my understanding is the bottom line is that just popping in and out, that may not give the courts the clear and convincing evidence that they need. It really comes down to the courts. It has to be clear and convincing evidence that this parent needs to have their rights terminated. I hope that answers your question.
Representative Webb.
Thank you, Mr. Chairman. My question is, and I'm sure there's got to be somewhere, but the definition of relative and how far that expands. We talk about grandparents, and we've mentioned aunt and uncle, and I'm all for good aunts and uncles and grandparents, but how far does this expand? And then the other thing was, is there any provisions to protect the child so the child doesn't end up maybe in a situation, but we don't want them to end up in a situation like like in the previous bill we've just discussed?
Senator.
Mr. Chairman, Representative Webb, that's a good question. I just can't imagine that the child would have an issue if the parents have been, unfit for many years or whatever, 18 months, 24 months, whatever, that they would probably, still want to go with mom or dad or whatever. The first part of your question, say that again?
The relative.
Oh, the relative, yes. Basically, this just says a guardian who is a relative of the child. We primarily, I get the stats, it's mainly aunts, uncles, and grandparents. I don't know if it could probably be a cousin, but I don't have any anecdotal ideas to even send down. The only ones I've heard from basically were aunts and uncles and grandparents. But it just says relative, and I don't know if that's defined in statute or not. Good question.
All right. Anyone else in the room wishing to testify on Senator Schuler's Senate File 22? Welcome back, Ms. Thompson.
Thank you. I did not intend to testify on this bill today. okay. And I just want to share some insight, a personal kind of story. My half-sister on my mom's side has 3 kids, none of which are in her care because she's consistently in and out of jail on drugs. She prostitutes herself out. Terrible situation for her. Her middle child grew up with me and my mom. My mom was the primary caretaker of him. We had him, she came, dropped him off, said, hey, can you watch him for a few hours? He was a few months old. We said, yeah, no problem. And then she left for about a year and a half. She came back, she goes, I want my son back. That kid was fearless of anything. He came back to us again. Will you watch him? And she was gone for another 2 years. That kid was scared of everything in the dark. You couldn't get him to go anywhere alone. So who knows? We had no contact with him with those 2 years that he was gone. So we don't know what had happened in those 2 years, but I can only imagine just based on her life and her story. Her third child, her recent one, the aunt is taking care of her. She went through the adoption process, which was, again, a fight tooth and nail because my sister would not terminate her parental rights. Turns out the aunt on the paternal side was not the biological aunt by any means, but she had care of her daughter for 24 months and decided to adopt her anyways because that's a long time to have a kid. Her eldest son, again, because she was such an unfit mother, the father actually took him out of state because she would not sign over her paternal right or maternal rights and had to fight tooth and nail again, once again, to have custody and fight for him as well. My mom moved to Florida. My mom, I will clarify, never once said that you cannot see your son, but she simply would not be a mother. There's times that while she had custody of her son recently because she wouldn't sign over her parental rights, my nephew would walk home from school and say, oh, my mom forgot me again, because she was just absent as a mom. So I just want to give that insight as a personal story.
Thank you. Chief?
Mr. Chairman, Chief Mike Thompson, Chief Police Evansville. A couple incidental things is I didn't intend to testify to this. Going back to Representative Filer, he makes some really good points to this. And some insight from the law enforcement perspective. A lot of times we get drug into these cases through grandparents, aunts, uncles that are taking care of these kids, and it's becoming more prevalent across the state. And also what Representative Webb brought up about relatives, and I don't know the definition statute, but we're finding, and we have a current case in Evansville right now where a 14-year-old juvenile ran away. His guardian is a stepfather, not a biological, but stepfather who's in Missouri, who couldn't deal with the kid, sent the kid to his stepson in Evansville. So we're now in the middle of this. So I think the one thing that this does actually helps bring stability to these children, as we talked about earlier about victimization with kids, but also these kids, they only have a small window. They have 18 years to be kids before they become adults. And there's one thing in my career of 21 years now, I've seen a lot of frustration with grandparents or relatives that are caring for these kids because nobody else is. And I think that's the one thing this bill does, is it helps start bringing more stability versus having the long fight that my daughter obviously just tested about with her stepdaughter, or stepsisters, sorry, half-sister. Sorry, long morning. With that, I stand for question, Mr. Chairman.
Thank you, Chief. These are complicated situations, but I think we want to make sure we stay on track on this bill, that we have to have a situation where we have a court-appointed guardian, and that guardian has the child for 24 consecutive months, and then the parent is deemed to be unfit by clear and convincing evidence. And those are the cases we're applying. Like you, I've seen many of these wide scenarios of steps, and, it can get very confusing, but I want to make sure we stay on track on this bill. Director Schmidt, maybe you can help us out a little bit here.
Thank you, Mr. Chairman, members of the committee. My name is Corin Schmidt. I'm the Director of the Department of Family Services. And this is an issue that is a little bit separate from us. So certainly talking about termination of parental rights is something that our agency and the families we work with deal with all the time, but that's due to some sort of allegation of abuse and neglect where the child has been placed into the state's custody. So our system works kind of separate from what is being discussed here. And I just wanted to make that clear because sometimes I think that gets a little confusing. But what happens in a termination proceeding is true for regardless of if the child has been in care or if a petition has been filed by a guardian. It's the same standards. We have the opportunity to file and to have standing if a child has been in the care and custody of the state for 15 of 22 months. What this bill is doing is suggesting that guardians who are not involved with the state, who are doing this as a very private family matter, also have some sort of standing to come to the court and say, for the last 2 years, we've had a legal guardianship, and that was a point that I wanted to make. This is with a child that has a legal guardianship in place. But that family cannot adopt that child until the rights of the parents have been terminated. And that's what this is getting at. This is saying that if we want permanency for this child, the parental rights first have to be terminated, and then that allows the child to be legally adopted. The child cannot be legally adopted if the parents still have rights. So it's a little bit of a legal technicality, and what we know in our system, in the child welfare system, is that we give a lot of attention to the parents' rights. That is primary, and we work very hard to reunification. But we also know that there is a point in a time where maybe the parents are not going to do what they need to do in order to be the best support to that child. And it's at that time then that there is that conversation about, has the state, DFS, and all of the supports done everything that they can to support that child and that family so that child can go home or stay home? And if the court says, yes, everything that you've been able to do, you've done, the parent has not, therefore, and the child has been in the care of 15 to 22 months, then that allows the state to say, we're going to move to termination. In this situation that Senator Schuler has brought up, there really isn't a trigger like that. And I think that's really what they're requesting. This is a policy statement. I'm not here to say one way or another. I'm just trying to give you how one system does have that available to it, whereas maybe a guardianship doesn't. That's happening outside of the government oversight of a custody issue.
So Director, call your attention to this word, the parent is unfit. So what's your experience in terms of statute and case law? At what point does a parent get deemed to be unfit?
Mr. Chairman, that's a case-by-case basis. The unfitness happens in the termination proceeding. What happens on our side in the juvenile court case is we're doing everything we can to get the parent fit. And at some point, then it's called reasonable efforts. Are we making every reasonable effort possible to get the family, the parents, to the place where they can take care of their children?
What are the kinds of factors a court would consider in terms of determining on a case-by-case basis, is this parent fit?
Mr. Chairman, so when we move to termination of parental rights, if that's the case, what the court is going to ask us is, did the state provide every opportunity for mental health and substance use treatment? Did that parent participate in mental health or substance use treatment? Because we know a lot of the cases that we're involved in are resulting from that. Did the parent provide the necessary support to the children while they were involved in state custody? Did they attend the visitation? Did they take responsibility for making sure that everything that has been decided by a case plan was complete? So the factors are going to be very dependent on the family, but the way the child welfare system works is we agree that this is everything that you need to do in order for the state, the courts, all the people that are involved to make a determination that, yes, you are fit, you're doing everything you need, but if you're not, then we have the ability to say it's time to pursue termination, and the court will say, state, did you do everything? And if they think we did, then that gives them the grounds.
So Director, in the majority of these cases where these children are with their grandparents or aunts and uncles, are they not under DFS authority, or is it a mixed bag?
Mr. Chairman, I was just asking the senator, and I know that Ms. Somerville is here too, about the information they gave, the number of grandchildren or grandparents taking care of grandchildren. I don't know what portion of those numbers include kids that are in our custody. But what I do know is about half of the kids that come into care are with some sort of known family member or friend. We call that kin, somebody who knows the child. So that kind of goes to that point about family and kin. Our goal is if a child cannot stay at home with their biological parents, our primary goal is to provide them with somebody who they know. We know how horribly terrifying it is for a child to be separated from what they know, good, bad, or indifferent. It is what they know, and to be placed with someone they don't know. So we do our best to try to place first and foremost with someone they know, whether that's a relative or a family member. And so we do that about half the time. What we also know is that in our cash assistance program, the program that provides actual cash to families, we have about, at any given time, 500 families who are receiving cash assistance. Half of those qualify for that program because they're taking care of grandchildren. So it kind of sizes up with what Senator Schuler was saying. I just don't have the data to tell you exactly what percentage of those numbers are child custody, child welfare involved, state custody involved versus private proceedings, which is what we really want. We really want those families to be able to have what they need to solve those problems themselves.
Thank you. We're coming up on 9:30. I want to make sure we get to Colin Hartley on Zoom. Are there any questions for the director? All right, thank you for
Thank
being
you.
here, participating. Bring in Colin Hartley. Good morning, Colin. Please tell us your name and what you'd like us to hear about this bill.
Good morning, Mr. Chairman and members of the committee. My name is Colin Hartley. I am a first-year student at Kelly Walsh High School. I am here today to talk to you about what it is like to be a child in situations like this. My biological mother has struggled with drug addiction for a very long time, and because of this, I have felt the impact of her addiction. When I was 3 years old, I had to have dental surgery due to meth mouth from secondhand in utero exposure. Another incident that I get flashbacks from is when my biological mother and father were in a hotel room together and they were beating on each other nonstop. I do not really remember a lot from back then, but what I do remember is that my biological mother would show up sometimes and just leave again. But a good thing that happened to me, in fact, one of the best things that happened to me is when my grandparents adopted me in October 2017. At the time, I didn't really realize that they weren't my actual parents, but as long as I can remember, my house has been my house. My parents have been my parents. We have a dog. I participate in the ROTC program. I get to see my cousins a lot, sometimes even too much of my cousins. Yet some people that I know aren't as lucky as me. I have a friend who also lives with his grandparents, but sometimes his mom shows up and says he has to live with her. Normally, he's back with his grandma after a few months, but every time it happens, he has to leave his friends, his school, and everything else behind. But there are many kids like me in Wyoming, and I feel really bad for them because I know exactly what it feels like to be in a situation like that. So I hope you guys vote for this bill, and thank you.
Colin, I very much appreciate you being with us today. You're probably getting to skip some class time to be with us, and but I think it's really important that we get that perspective. Thank you so much. Questions for Colin, anybody? Thank you again for joining us today.
You're welcome.
Somerville? Is Pat Hartley also waiting in Zoom? I think that's Colin's grandmother, right? She testified in Casper at the committee meeting, yeah. Ms. Hartley, good morning.
Good morning.
So,
I'm sorry I couldn't make it down this time.
well, you're one of these grandmother heroes out there. So why don't you tell us what you want us to know?
Okay. Good morning, Honorable Chairman and members of the committee. My name is Pat Hartley, and I come to you this morning as a mother and a grandmother. I appreciate Chairman Washut allowing me to share my story. I'll try to be quick, but I'm speaking not only for myself, but many of the grandparents, aunts, uncles, and other relatives who are raising children that they didn't anticipate. My husband and I are grandparents raising our grandchild. Both his mother and father struggled with addiction and were in and out of trouble with law enforcement and had no capacity to raise their child, my grandson. When they had him, my grandson was exposed to drugs, neglect, left in unsafe environments, and much more. My husband and I tried our best to help our child. We sent her to rehab several times, called DFS and law enforcement, but they were unable to assist due to the fact that when they would arrive at the location, parents had left to another county in Wyoming or another state, only to return in a month or two. I am now well aware of how adept addicts are at hiding and covering things up. From birth to the age of 3, our grandson spent the majority of his time at our home, where we would make sure all his needs, such as food, clothing, and medical care, were taken care of. In every way, he was our child. Shortly after his 3rd birthday, we obtained legal guardianship of him, but were unable to adopt him for 4 years until he was 7. During all this time, my daughter and her husband struggled with addiction and criminal activity, ending when my daughter went to prison and her husband left Wyoming permanently. During these 7 years, his parents would get clean for a short amount of time, only to start the cycle of drug abuse and criminal activity again, inevitably ending up in trouble. They would stay gone for many months, sometimes more than a year, then pop back in and then disappear again. It was a cycle that never seemed to end, elongating the legal process and turning my grandson's world upside down, which resulted in him losing all the progress he had made, being traumatized again, and losing the sense of security. The trauma continues to affect him to this day, years after his adoption was finalized. He is still receiving therapy and support, but didn't really make any forward progress until we finally adopted him and he was on stable ground. What I can share with this committee today is that he is doing well, and we hope that we have put him on a path different from his biological parents. There are many stories like ours, many relatives, mostly grandparents like us. They have legal guardianship over a child for more than a year, sometimes multiple years, and they can't move forward or are stuck in an endless cycle. One I know had been trying to adopt for more than 2 years, and even though one parent is in jail and the other is deceased, these grandparents cannot move forward. Another had legal guardianship for almost 4 years and has been told there is no way forward by the court because the parents object, even though the parents are not involved in the child's life and still cannot take care of the child. When you talk to any of us going through this situation, we would all tell you the same thing. There is no light at the end of the tunnel. There are so many challenges that come with raising grandchildren by itself: financial, emotional, mental health, and generation gaps. Personally, I've had to learn Snapchat and an Apple phone, which my grandson tells me frequently I still don't know what I'm doing. If the state wanted to sponsor a class to teach all of us retirees how to speak Generation Alpha, that would be a great idea. The legal expense and length of the process is another challenge. I'm not asking the committee to look at the cost today, but my hope is that the state can look at the legal process statute. There are really only 2 options for these children in a situation like my grandson's. 1, DFS takes custody and they are placed in foster care. Or number 2, a family member steps up and takes legal guardianship on their own initiative. The second is truly a demonstration of a Wyoming value of family taking care of family. And in my opinion, it is always the best option, rather than putting the burden on the state and potentially placing the child with strangers. The central issue in moving forward from legal guardianship to adoption rests on the termination of parental rights. I have been told that a child in DFS custody is eligible for adoption and termination after 15 of 22 months in foster care. At this time, there is no equivalent process for those that stepped up, took legal guardianship of a child that is a relative with no DFS involvement. We can apply, but there are no guidelines in statute as to time frame or consideration of length of time. In our case, we had to wait until the parents did things so egregious that one fled the state and the other was sent to prison here in Wyoming on charges not related to the child. Even then, the court would not terminate rights until the parent in prison willingly gave up her rights, hence the 7 years it took to complete the adoption. One thing that no one seems to talk about is that when you have a family member with an addiction who is in and out of jail or prison, it just doesn't affect that person. Addiction is often not only just addiction, it leads to a life of violence, crime, fraud, and more. It is a living hell for the entire family, multiplied exponentially when there are children involved. When a child cannot be raised by their parents, it is horrible. I say that as a parent and as a grandparent that prays every day that my child will get better. And I hope someday she will be well enough to have a relationship with her child. This bill represents a chance to encourage Wyoming families to take care of their families, takes the burden off the state, and gives the child a chance to maintain the stability and success they have worked so hard to rebuild. Thank you for your time.
Thank you, Ms. Hartley. That's very helpful. And I think it's information the committee needed to hear, and we appreciate you taking the time. And I know you were willing to drive down, but we weren't absolutely sure we'd have time to hear this bill today, and that we might have to push it off till Monday, and hate to drive back and forth to Cheyenne twice. And so I do appreciate you joining us by Zoom.
Thank you.
Committee, we got 20 minutes left. I think we have one more witness on Zoom, Mr. Lassiter. Oh, you have a question? So, Vice Chairman?
Mr. Chairman, I just wanted to say something to Ms. Hartley. She was still available.
Is she still there? Still there. Go ahead.
Oh, well, I understand that it may be hard to communicate with younger generations at time, but your love for them is not missed in translation. So thank you for advocating for what you do.
Thank you, sir.
All right, Mr. Lassiter. Mr. Lassiter, we only have a few minutes, so please be brief, but tell us what you want us to hear.
Chairman Washit, committee, can you hear me?
Yes.
All right, thank you for allowing me to speak today. I'm not sure how to turn on my camera, or I would do so. Maybe I can. My wife and I are raising both of our granddaughters. One we have through a guardianship. The other one I actually was allowed to adopt as a co-parent back when we lived in Missouri. The one grandchild, the oldest, was a year behind in school when she came to live with my wife and I. Our youngest had missed over half of the days in Head Start. And since then, now they are both on the honor roll and doing remarkably well. But I understand the struggle. You know, I've always been a very strong conservative and parental rights guy. And I actually had to back up, you know, when your circumstances change, then sometimes it changes your perspective. And I think this bill is a very good bill. I think that it may not go far enough, and I think that could be addressed later. But one of the things that I would ask is that the 24 consecutive months, I don't agree with that, because there are parents, as you know, other people have testified, that's in certain situations that will use that 24 months consecutively. You know, that they might leave the child with you for 18 months or 19 months, and then all of a sudden show up for a month, and then the clock starts over. And so one thing that I would ask is more along the lines of what the DFS proposal is, or even 24 months non-consecutively, because, you know, these children, I hope that's everyone's focus, and I am sure that it is on this committee. And I thank you for your work, and I'm sure it is for Senator Schuler. But these children are the ones that suffer when they are not in a stable home life, and when they are not taken care of and put in a variety of very sad situations. And it's not that the grandparents and relatives don't still love the parents of those children, because we do very much. But, you know, the children have to come first. And I just ask that this bill be passed, and that we consider and continue to put the children first. Thank you, Chairman.
Thank you, Mr. Lassiter. Valuable information for the committee to hear. Any questions or comments from Mr. Lassiter? Thank you again for joining us, and your video worked just fine.
Thank you.
All right. Anyone else in the room for Senate File 22? Anybody else on Zoom? Going to close public comment. Oh. Yeah, Ms. Chambers, looks like no interest? Do you have a question for Ms. Chambers?
I do.
Come forward, please, Ms. Chambers. You're drafted.
So the price is right.
Representative Bratton.
Thank you, Mr. Chairman. So as I read this statute, and I'm going to read it, grounds for termination of parent-child relationship. The parent-child legal relationship may be terminated if, and I want to read this number one because I don't understand why it has been so difficult for these parents or these grandparents to get custody, and all they have to do is fulfill this. The child has been left in the care of another person, that would be a grandparent, would be one of those, without provision for the child's support and without communication from the absent parent for a period of at least 1 year. So 1 year, I feel like the statute that's being added is less restrictive than that. That's 2 years. So just 1 year, and the court may disregard the occasional contributions or incidental contacts and communications. So that covers the concerns of, you know, just the flybys. For purposes of this paragraph, a court order of custody shall not preclude a finding that a child has been left in the care of another person. So, I mean, it seems to me that those grandparents, I mean, God bless them, should be able to have I don't understand how the current guardian process, you know, is not working. Don't they have the ability to petition for termination? And why aren't the courts giving them termination? So I guess my concern is, why isn't that working so that we, you know, that this has been brought forward is the first question. And then the second question is what is being added less restrictive? Like 1 year sounds better than they have to wait 2 years to me. So please help me out with that.
Ms. Chambers, a little out of your wheelhouse, but
You're the lawyer.
chime in if you wish.
Chairman Wasser, Representative Bratton, I will be very candidly, I was doing other research in the back of the room during the majority of this discussion because this is a bit out of my wheelhouse. I would just defer to the bringer of the bill and the gap that they felt that this was filling. But I will be very candid with you. I do not have the current language in front of you, but what I do know, just anecdotally, is there is so much nuance that goes on with these cases, and being a parent is a fundamental right, and that is a very high threshold before you get to termination. It is the highest. A fundamental right is the highest level of rights. So these are not taken lightly, and that did not answer your question, and I apologize, but that's what happens when I'm in the room. I should have left. No, I'm just kidding.
I'm glad you did. All right, thank you.
Okay. So with that, I'm going to close public comments. Senator Schuler, you want to take one last bite at the apple?
Thank you, Mr. Chairman. And again, I certainly understand the question that Representative Bratton's bringing forth. I think that first ground for termination, which just basically says the child has been left in the care of another person without provision for the child's support and without communication from the absent parent for at least 1 year. It could be something like they could send a Christmas card. And then that, then that takes care of that. The absent parent, they don't have to even come to the house. They don't have to be around them. So as much of a letter or a Christmas card, whereas the one that we're adding basically just says, hey, this grandparent, this aunt and uncle, they've done the work, they've been appointed a guardian, they've been taking care of them, and before they had no standing, they had no rights to be able to go and ask for a termination of parents' rights. I guess they could in this one, but I just don't, I think the problem that we're trying to solve is to try to give those relatives a chance to be a bigger part of, to be able to adopt, to be able to give some stability. And I think this 10th ground for termination, it seems to get to the mark. I hope that answers your question.
Senator, if that Romanet were working, we probably wouldn't have this bill before us. Is that your testimony?
Yes, sir, it is. Thank you, Mr. Chairman.
Other questions for the senator? Any final comments? Senator, thank you for bringing, I guess I'm inclined to look at the substituting the 15 of 22 months for the 24-month language. Any comment on that thought to make it consistent with the DFS language?
It's interesting, Mr. Chairman, that you brought that up. Thanks for that question, because that was brought up, that if the child is in, foster care, it's only 15 to 22 months, and we're asking for, at least 24 consecutive. So I think that would be certainly worth taking a look at.
Okay, thank you very much. With that, I'll close public comment. Committee, your preference? Moved by Filer, second by Singh. Any amendments? I'm going to withhold mine for maybe committee of the whole or second reading. I have to give that some thought and contemplate that, but I think it seems to make sense to be consistent between the DFS standard and the grandparent standard. And I just want to take this opportunity to hats off to these grandparents and aunts and uncles. And you imagine what the cost would be for the state of Wyoming if those kids were completely dependent upon the foster care system and state support. It would be tremendous. So these family members that have stepped up, the mental health and addiction issues are just rampant in our state. And so I'm just so thankful that those family members have stepped up. Representative Kelly.
Thank you, Mr. Chairman. I just wanted to make some concluding comments as well. I have continued to become friends with many of the teens that I'd worked with in the past into their adulthood. And I see that this is an ongoing issue for them well into adulthood. Quite often feel like I wish I could do more to help my friends. And so I appreciate this opportunity to actually get to take a small step to try and make things easier for people going through this. So thank you for being here.
Representative Brady.
Thank you, Mr. Chairman. I appreciate your comment about these children not being such a burden in DFS and such on our state, but even more so, like we were speaking of, when these children are with kin, I think that's where the big bonus is. So I appreciate this bill. Thank you.
Call the roll.
Representative Brady?
Yes. Aye.
Representative Breton?
Aye.
Representative Chestek?
Aye.
Representative Filer?
Aye.
Representative Kelly?
Aye.
Representative Lean?
Excused. Did she leave her vote? Okay, excused.
Representative Singh?
Aye.
Representative Webb?
Aye.
Chairman Washut? 8 ayes, 1 excused. Do pass.
You have a volunteer on the floor. Do you have one of your co-sponsors ready to do it?
I'm sitting right next to you.
All right. Representative, and I'm a co-sponsor as well, so Representative Chestek, thank you for stepping up for that one. Committee, we stand adjourned until Monday morning. Thank you all for the long trip down and providing testimony today. Thank you.